Can you guys introduce yourselves?
I am State Senator Mike Skindle. I have with me a co-plaintiff, former State Representative Dennis Murray, as well as the Executive Director for ProgressOhio, and we have a lead counsel in oral argument here today, Maurice Thompson from the 1851 Constitutional Law Center. This case is about the public right to keep check on what the General Assembly is doing in enacting certain types of legislation. And I think the most visible question that was posed in the courtroom today was that posed by Justice Paul Pfeiffer, who said, did the General Assembly in this particular legislation build a wall with the courthouse behind that wall and then make it difficult to find the door? And that's exactly what the legislature did, so that the constitutionality of JobsOhio could not be challenged. With that, I'd like to call upon Maurice Thompson.
Thanks. I'd be glad to answer any questions that any of you have about the litigation. I suppose the first thing I want to do is thank Senator Skindle, Representative Murray, and Brian Rothenberg from ProgressOhio for permitting us through 1851 to argue the case. This isn't, even though we did it for free, I suppose we could thank each other afterwards maybe if we win. But this is an issue that has been on our radar since at least 2008. There's been this serious glitch in Ohio law when it comes to these corporate welfare provisions in the Ohio Constitution. A lot of people don't realize how great the Ohio Constitution is at prohibiting handouts to private corporations purely for private interest. It happens to have amazing language, yet that language is worthless if it's not enforced in the courts, because the legislature, as we know, does not enforce it. So the real problem we have here is this collective action problem that I referenced in the action. The notion that this hurts all Ohioans equally. It may take $1 or $2 out of each of our pockets over the long run, maybe 10, maybe 20, maybe 100 over the long run, but it's not enough for any individual Ohioan to have a personal stake or to bring a claim, but it's certainly enough for those on the receiving end to go to the legislature and get those benefits from them and do whatever it takes to get those. So we have a serious disparity, and it's the average citizen that's harmed in their capacity as a citizen and as a taxpayer. So when it comes to Article 8, when it comes to Article 13, these anti-cronyism, anti-corporate welfare limitations, these prohibitions on special acts, it's imperative that the average citizen have standing, because frankly, in almost all of these cases, nobody else will. That means the legislature can legislate at will without any sort of check whatsoever. And we all know from elementary school, for God's sakes, that checks and balances means the judiciary reviews the constitutionality of the legislature's acts to prevent the rule of law from being dissipated and for the Constitution to mean something. Let's remember, the Constitution is a contract between the people and the government. And it's the people who are the real party in interest to enforce that contract. And that's what we're trying to do here today.
It's really two separate questions. Are you confident that you made your case adequately, and do you think the Supreme Court will grant standing?
We made the case as best we could. We think we have a strong case. We think we have a meritorious case. We think we deserve to win the case. And I think that we will win the case. I don't exactly know which justices the votes will come from or exactly what they'll say, but if they don't want to take a black magic marker and redact half of the Ohio Constitution, then they have to rule in our favor. And I don't think they want to do that. I think they recognize that this body has a place in our state government, and that place will be lost if ProgressOhio doesn't have standing here.
Two questions, Maurice. Senator Skindle talked about the comments by Judge Pfeiffer. Can you name any other justices today and their questions that think bode well for your case?
Well, you know, trying to predict the outcome based upon oral arguments, I've found always to be a crapshoot. About a year ago here, Justice O'Connor called my client a fraud and then ruled in our favor, you know, after the oral argument. So I've tried not to make predictions, but the court was very skeptical of the state's claims, and rightfully so. If you heard what the state said we have standing, we just only have it original jurisdiction in the Ohio Supreme Court, even though they wrote a law that says you've got to bring it in Franklin County Common Pleas Court. How beautiful it must be to be the state of Ohio and to pass this unconstitutional legislation that channels the case quickly into Franklin County, and then to say that, oh, these people understand because they didn't wait long enough to develop an injury and because they brought it in the court we told them to bring it to. Frankly, their arguments border on absurdity, and the court will really have to bend over backwards to uphold the 10th District's case. And also, I should say, the 10th District's ruling was even more absurd than the arguments you heard from the appellees today. Interestingly, almost none of the state's arguments are the arguments that the appellate court made. They're completely different arguments because even they don't want to defend the appellate court's decision, but that's really what's under review here.
Follow-up question.
If I may add to that.
Sure.
I think one of the things you saw the court struggling with was the fact that between the General Assembly and the administration, which is prosecuting this case or attempting to avoid our ability to prosecute this case, what you see is a shell game, and that's troubling the court because at times they're saying, well, you have to file here, but then you've got to file within this period of time, and you have to have some specialized injury, or you've got to have some kind of action where you can bring a mandamus action, which is where you're saying to a government official, no, you must do something that you did not do. Those things don't all exist in one spot in this case. And when you heard Chief Justice O'Connor ask the question, if not these plaintiffs, who? And if not now, in this case, when? That was the most important question that was asked, and there's never been an adequate answer provided to that question. None of the arguments that were advanced in the trial court, Court of Appeals, or the Supreme Court by the opposing parties in this case ever answered that question. And the answer is there is no one who can file those actions. And what they have effectively done is they have said to the judiciary, if there is no standing in this case, there is no one who will ever be able to conduct a review of this legislation.
Follow-up question here. As we know, we have a Constitutional Modernization Commission underway at this very point. At this point in time, what are the lessons that group can learn about modernizing the Ohio Constitution based on this case?
From a citizen standpoint as opposed to a legal standpoint. I mean, look, folks, the legislature crafted legislation to make this complicated and difficult. Nothing decided in the courtroom today actually deals with the constitutionality today of JobsOhio. The whole point here is, if we have a constitution and it can't be enforced, and a legislature can just pass anything they want, who defends the Constitution of the state of Ohio? Now, this has brought together people as diverse as the 1851 Law Center and the Ohio Roundtable, and Rob Walgate is here too. He's got a case that is affected by some of this. But it is a very simple thing for non-lawyers to understand. Nobody has ever ruled on the constitutionality of JobsOhio. And I'm a non-lawyer, so I'm watching this. And I know that this standing argument is going to play a big role not only in this case but in cases in the future. But are we going to have a constitution that is defenseless is the bottom line. And I just believe in the American system of government and checks and balances, and that in the end this court will preserve their role and preserve the role of Ohio citizens to make sure that their Constitution defends them against actions of a majority that are wrong.
The chief talked a lot about these folks who would be aggrieved in terms of people doing business with JobsOhio who are deprived of a contract, who might have had a liquor interest. Those wouldn't have been constitutional grievances, would they?
Normally they would not be constitutional. It would be based upon the action of JobsOhio. So what the legislature did on this is said that you have 90 days. If anybody has a constitutional claim, you have 90 days to bring it forward in the Franklin County Court of Common Pleas. Then there's another section that said if somebody's aggrieved by an action of JobsOhio, they have 60 days to bring it into the court. The problem with establishing the 90-day effective date, as was stated, it does not give time for people to be aggrieved. So the basis of standing has generally been considered at the federal level is that you're aggrieved, that somehow you received a particularized, individualized harm by the state action or the state provision. In this case, it does not allow anybody, and there may not be anybody that may be aggrieved directly from this, but we as a public are aggrieved by this particular piece of legislation.
And you know, I just want to add, the lawyers, but look, they told us we had 90 days. JobsOhio didn't exist. I'm not even sure the liquor profits money was even discussed at that point in time. I'm trying to go back and remember. The fact of the matter is they crafted this in a way to make it difficult to defend Ohio's Constitution. And now they're saying that the only person with the right to defend Ohio's Constitution is somebody that has a financial transaction. That our Constitution is predicated on financial transactions. And I just believe that this court is going to understand the importance of our Ohio Constitution and rule the right way when it comes to that. And I think they were struggling with that in the courtroom.
I want to add, well, we all want to speak on this topic. The state's premier argument along these lines is that disgruntled public employees who work for the Department of Development and perhaps lost their job because of the JobsOhio creation would have standing to challenge this. But is that really the kind of government that the Constitution gives us, or that we want, where disgruntled public employees become an elite status of Ohioans who have standing to enforce the Ohio Constitution while others don't? And the answer is no. Not only do you not want that, but it's perverse that somebody with a personal benefit, with an axe to grind, would be the ones charged with determining the constitutionality of this huge system of government and enforcing these lofty constitutional principles when frankly they don't care and all they want is their job back. So what better plaintiffs could you have than those conservative, libertarian, and progressive organizations that as a mission oppose corporate welfare and seek to enforce these corporate welfare limits in Ohio's Constitution? So who is better situated than the parties here today? And the answer is, of course, nobody.
Well, I suppose this could be a question for the state or JobsOhio, but isn't it that the state still operates the liquor business? So I was confused how someone with a liquor issue could sue JobsOhio, because wouldn't they still be dealing with the state and operating under state law?
They'd be shooting themselves in the foot. I mean, if you're a bondholder, if you're dealing with JobsOhio, why would you bite the hand that feeds you? That's the state's argument, that the only person withstanding is those who would seek to bite the hand that feeds them. And again, that's the perversity of the incentives here when there's an Article 8 or 13 violation, is it only gives big benefits to these people and just takes very small amounts from the rest of us.
I just wanted to add an historical perspective. You know, one of the darkest hours in our state's history was back in the 1840s. That's why we had the Constitutional Convention back then. That's why we still have all these foundational elements in our Constitution today. You'll often hear sometimes only history professors say, those who don't know history are bound to repeat it. Well, the framers of the 1851 Constitution took great pains to make sure we wouldn't forget it, that we wouldn't get into the same financial trouble back then, and they put safeguards in place. The administration and JobsOhio tend to treat those folks who drafted that Constitution as a bunch of rubes and a bunch of farmers. But the fact of the matter is, as Maurice indicated, there is some profound wisdom that is contained in that Constitution, and we and the court have an obligation to honor that wisdom.
Any other questions? And if not, thanks. Rob's here as well if you have questions.